On July 12, 2016, an arbitral tribunal issued its award in the so-called South China Sea Arbitration. China rejected the award from the start.
For years, many Western commentators have presented the case as proof that China respects international law only when it serves China's interests. But does the arbitration itself stand up to the same legal scrutiny?
A report published by the China Institute for Marine Affairs argues that the case was not simply an impartial legal judgment. It argues that a dispute over territorial sovereignty was reframed as a dispute under UNCLOS.
And it is not alone. A number of legal scholars outside China have also raised serious questions about the award and the tribunal's reasoning. So, a decade on, let's revisit this controversial case.
UNCLOS deals with maritime rights. It does not decide who owns land or islands. So how did the Philippines try to bring this case under UNCLOS? By using what lawyers call a mixed dispute strategy.
The approach is simple. Take a dispute that is fundamentally about sovereignty, combine it with questions of maritime rights, and then treat the sovereignty issue as merely incidental.
Once that is done, the case can be repackaged as a question about interpreting UNCLOS.
A study by the British Institute of International and Comparative Law described this as a deliberate strategic choice.
French scholar Jean-Louis Etienne put it even more sharply. He described the approach as an astuce procédural, a procedural trick designed to keep the case within the tribunal's reach. Why does that matter?
Because a tribunal may decide technical questions about maritime rights without resolving the sovereignty dispute at the heart of the case. And when the core dispute remains unresolved, the conflict does not disappear.
Pierre-Michel Eisemann, a professor emeritus at Paris 1 Panthéon-Sorbonne University, warned that the award did not genuinely resolve the South China Sea disputes. Instead, he argued, it could create new disputes in other waters that had remained peaceful.
China ratified UNCLOS in 1996. The report's argument is not that UNCLOS is the problem. Its warning is that the convention is weakened when courts or tribunals stretch its terms.
French scholar Romain Leboeuf made a similar point. He wrote that only those who were already disposed to be persuaded before the award was rendered will be convinced by the arbitrator's reasoning.
That is the real danger. A ruling may be legally elaborate, but when it is seen as politically driven, it does not settle disagreements, it hardens them.
Revisiting this award is not a rejection of international law. It is a reminder that international law must be applied with restraint, consistency, and respect for its limits. International law should help lower tensions, not become another tool for political maneuvering.